from Oklahoma. Chairman Cole's recognized.
Thank you, Mr. Chairman. Mr. Dellinger, just on a lighter note, let me assure there's more drinking that goes on here than you know, and I'd be happy to show you where on some occasions. So not all the old Congress is lost. You know, frankly, we don't very often, we normally just have members testifying. And so we don't see this collective display of brilliance and eloquence. It's usually much simpler to get through. I found I have a predisposition. I haven't made a final judgment in this case, and I find myself sometimes going back and forth, quite frankly, as you make your various points, and I mean that quite sincerely. And so I appreciate what all of you have brought to the table in that regard. And I have to say, as a sort of upfront assumption, as a conservative, I hate going to court. I mean, I consider it the civil equivalent of war. It's unpredictable and it's expensive. So I don't like doing it, and I've never taken anybody to court in my life. Have never been taken to court by anybody in my life. So yeah, I take this as you know, not a partisan exercise, but something that's pretty serious thing for us to consider here. And it's interesting to me that four people of clearly your distinguished backgrounds and your abilities are on different sides of the issue effectively. So it tells me there's a real question here. It doesn't mean we should go to court, but it does tell me there's a lot more, you know, intellectual credibility to both these positions than partisans on either side might allow. Let me begin with you, Mr. Dellinger, if I may, because I want to get something on mind. If I remember correctly, you made the point that perhaps the 113th Congress wouldn't have the standing to deal with a law passed by the 111th. If that's the case, you know, if the 111th passed a law that was going to be phased in over a period of time that would outlast its own existence, does that mean a future Congress would have effectively given up all right to go to court on this particular issue or any particular issue?
Well, you know, that's a good question. I don't think they would have given up the right, because I don't think they had the right to begin with. And my point about the 111th and 113th having passed the law and the 113th House, a House of the 113th Congress proposing to go to court, is simply, more than anything, a rhetorical way of emphasizing the point that Chief Justice Rehnquist has made, Chief Justice Roberts has made, Justice Scalia has made, and that is when the legislation is passed, your job is done. Your job is done. So even if this were fast enough that the a House of the 111th Congress could have gotten to court, when the legislation is passed, your job is done in terms, and how it is, you have no legal interest, different from the rest of American citizenry, in how that legislation is implemented. All of us care about it. But the only people who get to sue are those that are adversely affected and can bring a lawsuit. And that doesn't include the members of the House whose job was done when the bill was passed.
Okay. If I want to move, because I have questions for all of you in limited time. Well, the chairman's been very generous. And again, if I remember correctly, Mr. Lazarus, you made the point that this is, you know, you can extend the law or normal delays and normal implementation things. How many delays? I mean, you know, when we talk about the business mandate, we're talking about 2 delays, not 1, and we don't have any certainty, quite frankly, that will happen the next time. So is there some number of times that they can do this? Because remember, when they delayed it the first time, they said, we'll have it ready by this date. Then they delayed it again. So where does it end that the executive branch can change what's clearly written in statute, just saying, well, you know, to make this, to effectively implement it, we've got to stretch it this far and then this far again. Is there a number of times they get to do this?
Well, I think that's a good and a tough question. Oops. It's so tough I decided not to use the mic. That's a good and a tough question. What the law provides, what the Administrative Procedure Act provides, is that a court can compel an agency to take action it has delayed taking when it's been unreasonably delayed. Unreasonable is not a very precise term, certainly, but I don't know how it could be written in any other manner. it depends on what the circumstances are, and as I indicated, there have been times when courts have told agencies it's now time to get your act together and do this. Those cases have been rare. They've involved much longer delays than the current one, and they've involved powerful evidence that the agency is not merely trying to phase the law in; it's trying to not enforce it at all. And there have been past, as I said, and as Professor Turley has noted, there have been flagrant instances of administrations simply sitting on their hands and not carrying out laws, and that clearly is illegal and unconstitutional.
What if you wanted?
It's another question, though, whether how to deal with that, and the courts have trouble dealing with it. Congress is really the place to deal with that, but Congress, what Congress should do is what Congress did in the case that Congressman Burgess referred to, is pass a new law that makes it clear what they want, or use other powerful sources of leverage that Congress has.
So we could only act legally if both sides, or if both houses were controlled by the same party and largely in agreement. I mean, that effectively disenfranchises either from ever acting independently.
Well, I don't think that's right, and I of course I share the experience that Walter had with Congress's past. We're both pretty grown up in that respect, as it were, and often we've had Congresses in which the different houses were in the hands of the other party, but they still were able to work together and make legislation happen. So I don't think it's beyond the power of the Congress to do that. Okay,
let me move to Ms. Foley, and actually you may want to comment on a couple of things, but there's one in particular I wanted you to address, because we've sort of had this discussion, it seems to me, that do we have to use every single weapon before we go to court that's available? That is, are we required to cut off funding even though there may be a lot of collateral damage? Are we required to try to impeach even though impeach but not convict? I mean, it seems to me like, and believe me, I think it's wise to avoid going to court. As I said, I don't like going there, but it seems to me that there's sort of an undertone here that at least in the minority position, that we should never go to court until everything else possible has been done. That sometimes is not the prudent thing to do. You know, so it's paralyzing the country in an impeachment debate or something, maybe, and it may not rise to that level. We're not talking about high crimes and misdemeanors here. We're talking about a fundamental disagreement about the appropriate roles of the branches.
Yeah, I think that's right. I mean, as I stated in my opening statement, you know, I think that a lawsuit, although it's not something I think Congress should rush into, I think if it's carefully tailored and it satisfies that four-part test, which provides a very clear limiting principle for the court to adjudicate, a lawsuit may be the most proportionate, most appropriate, tailored response to a failure to faithfully execute the law. Because think what's going on here. What you want as Congress is to faithfully execute the law. For example, you wrote a law that said the employer mandate shall take effect beginning January 2014. That's as clear as a bell. It's unambiguous. And so what are you supposed to do? Pass another law to say we really, really mean it this time? That doesn't make sense. Are you supposed to impeach the president or maybe a lower official when actually you may not think the president should be removed from office? Maybe you just think the president should faithfully execute the law. That, you know, impeachment process is very divisive. It's very drastic. This is a less drastic remedy. What are you supposed to do with appropriations? Are you supposed to cut off appropriations for an unrelated program that you otherwise support because the president is failing to faithfully execute the Affordable Care Act? What do you cut? Do you cut school lunch programs? Do you cut Medicare? Do you cut Social Security? And if you do that, if you cut some other program that's unrelated to the president's failure to faithfully execute, then what you do is you make your constituents mad, right? You go back home to your town hall meetings in August and they say, why did you just cut the school lunch programs? And you say, well, I cut them because I'm trying to get the president to faithfully execute the Affordable Care Act. They don't understand that. When you point the finger to the president will then point the finger right back at you and say, well, I didn't cut the school lunch programs. Congress cut the school lunch programs. And what we have is a classic finger-pointing exercise. That's called a deficit of political accountability to us legal geeks. The Supreme Court has made it absolutely clear in its separation of powers jurisprudence that the reason we have both vertical federalism, separation of powers, and horizontal separation of powers is so that when somebody does something bad to the American people can know who's responsible for the harm that they're suffering. And I think in this instance, you wouldn't have that if you cut off appropriations. So frankly, a lawsuit is the most targeted, most tailored, conservative response to a failure to faithfully execute.
Let me ask this to you, Mr. Turley, and posit you, at least the way I think things have gone. The administration made a decision to delay. As our friends on the other side have made the point on several occasions, actually a decision we agree with in some ways. That's absolutely true. We also said, then if you're going to do that, we think you also ought to delay this, the individual mandate. Do them both. We'll pass separate pieces of legislation for them both, but don't subject one part of the American people while you exempt another part, particularly when you're subjecting almost everybody individually and or exempting almost everybody that's in a business, but if you're not, you're going to take it. We just don't think that's fundamentally fair, but we're willing to work with you on this. And then we're not talking about elimination. Come back in another year, maybe everything will be ready to go. So it's not as if Congress didn't try to work with the president, and it's not as if for an alternative. It's just, no, I have the authority to do it here, and I don't have to do it there. I mean, that, to me, suggests that that is grounds for a lawsuit. Look, we disagree. We don't think you have the authority to do both of them on your own, let alone pick and choose which ones you're going to do. But we're willing to say, you think you got a problem here? Let's sit down legislatively. Let's acknowledge that. We think there's a serious. So I don't know if that impacts the lawsuit directly, but it does suggest to me that we have an executive branch that won't work with the legislative branch in this area that was willing on this topic at least to work with them.